Who wrote the U.S. Constitution?
In spirit, the U.S. Constitution was created by all of the 55 delegates to the meeting that convened on May 25, 1787. In Philadelphia's Independence Hall. Thomas Jefferson, 1743–1826, called the Constitutional Convention an assembly of demigods. And with good cause, the delegates were the young nation's brightest and best. When the states had been called upon to send representatives to the meeting, 12 states answered by sending their most experienced, most talented, and smartest men, Rhode Island, which feared the interference of a strengthened national government in state affairs, sent no one to Philadelphia. Even in such stellar company, the document did have to be written. While many had a hand in this process, it was New York lawyer and future American politician and diplomat Gouverneur Morris, 1752–1816, who actually took on the task of penning the Constitution, putting into prose the resolutions reached by the convention. Morris had the considerable help of the records that James Madison, 1751–1836, of Virginia had kept as he managed the debates among the delegates and suggested compromises. In that capacity and in that he designed the system of checks and balances among the legislative, Congress, the executive, the President of the United States, and the judicial, Supreme Court. Madison had considerable influence on the document's language, quite rightfully earning him the designation Father of the Constitution. The original document, drafted by Morris, is preserved in the National Archives building in Washington, D.C. While the Constitution has been amended by Congress, the tenets set forth therein have remained with Americans for more than 2 centuries, and they have provided proof to the countries of the world that a constitution outlining the principles and purposes of its government is necessary to good government.
What does the Declaration of Independence say?
The Declaration of Independence, adopted July 4, 1776, has long been regarded as history's most eloquent statement of the rights of the people. In it, not only did the 13 American colonies declare their freedom from Britain, they also addressed the reasons for the proclamation, naming the causes which impel them to the separation, and cited the British government's violations of individual rights, saying the history of the present King George III of Great Britain is a history of repeated injuries and usurpations, which aimed to establish an absolute tyranny over these states. The opening paragraphs go on to state the American ideal of government, an ideal that is based on the theory of natural rights. The Declaration of Independence puts forth the fundamental principles that a government exists for the benefit of the people and that all men are created equal. As the chairman of the Second Continental Congress Committee that prepared the Declaration of Independence, It was Thomas Jefferson, 1743 to 1826, who wrote and presented the first draft to the Second Continental Congress on July 2, 1776. The passage that is most frequently quoted is this: "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights. That among these are life, liberty, and the pursuit of happiness. That to secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed, that whenever any form of government becomes destructive of these ends, it is the right of the people to alter or to abolish it, and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to effect their safety and happiness."
Why did John Hancock go down in history as the notable signer of the Declaration of Independence?
Most Americans know that when they're putting their John Hancock on something, it means they're signing a document. It's because of the 56 men who signed their names to the historic document. It was Hancock, 1737 to 1793, who, as President of the Second Continental Congress, signed the Declaration first. The events were as follows. On July 2, 1776, Thomas Jefferson, 1743 to 1826, presented the draft of the Declaration to the Second Continental Congress, which had convened in Philadelphia, Pennsylvania, more than a year earlier, on May 10, 1775. The congressional delegates of the 13 colonies then deliberated and debated the draft, making some changes. A section was deleted that condemned England's King George III, 1738 to 1820, for encouraging slave trade. Other changes were cosmetic in nature. On July 4 the final draft of the Declaration was adopted by Congress, and it was then that it was signed by Hancock. The document was then printed. A few days later, on July 8, the Declaration was read to a crowd who assembled in the yard of the State House. On July 19 the Congress ordered that the Declaration of Independence be written in script on parchment. It is that copy that in early August was signed by all 56 members of the Second Continental Congress. The Declaration of Independence is housed, along with the U.S. Constitution, 1788, and the Bill of Rights, 1791, in the National Archives building in Washington, D.C., where it is on display to the public. John Hancock went on to become governor of Massachusetts, from 1780 to 1785 and from 1787 to 1793.
What does the Security Council do?
According to the UN Charter, the functions and powers of the Security Council are to maintain international peace and security in accordance with the principles and purposes of the United Nations, to investigate any dispute or situation which might lead to international friction, To recommend methods of adjusting such disputes or the terms of settlement, to formulate plans for the establishment of a system to regulate armaments. To determine the existence of a threat to the peace or act of aggression and to recommend what action should be taken, to call on members to apply economic sanctions and other measures not involving the use of force to prevent or stop aggression, to take military action against an aggressor. To recommend the admission of new members, to exercise the trusteeship functions of the United Nations in strategic areas. And to recommend to the General Assembly the appointment of the Secretary General and, together with the Assembly, to elect the judges of the International Court of Justice.
What were the intolerable acts?
The so-called intolerable acts, also known as the coercive acts, were 5 laws passed by the British Parliament early in 1774, intended to assert British authority in the Massachusetts colony. The measures were seen as punishment for the Boston Tea Party, December 1773. In brief, the laws enacted the following: closure of the port of Boston, an English trial for any British officer or soldier who was charged with murder in the colonies, the change of the Charter of Massachusetts such that the council had to be appointed by the British and that town meetings could not be held without the British appointed governor's permission, the requirement that the colonists house and feed British soldiers, and the extension of the province of Quebec southward to the Ohio River. While the British intention was to bring the Massachusetts colony under control, and actually the Fifth Act was not intended to have any punitive effect on the colony. The result was instead to unite all the colonies in opposition to British rule. In this regard, the Acts are seen as a precursor to the American Revolution, 1775–83.
What was the Virginia Plan?
It was the famous plan, drafted by James Madison, 1751–1836. Put forth by the Virginia delegates to the Constitutional Convention, which convened on May 25, 1787. After taking a few days to set the ground rules and elect officers, on May 29 the delegation from Virginia, led by Edmund Jennings Randolph, 1753–1813, proposed a plan to write an all-new constitution. Rather than attempting to revise and correct the weak Articles of Confederation, there was opposition, sometimes called the New Jersey Plan, and the issue was debated for weeks. Eventually, a majority vote approved the Virginia Plan and the delegates began work, drafting a document that would provide a strong national government for the United States.
What is the Palestine Liberation Organization?
It is a group formed in 1964 by Arabs in Palestine, a region coextensive with the nation of Israel. Known as the PLO, The organization seeks to establish an area of self-rule for Muslims. Dominated by then guerrilla leader Yasser Arafat, 1929 to 2004. The PLO regarded Israel as an illegitimate state and became determined to establish a Palestinian state in the region. In 1974 the PLO was recognized by the United Nations and by Arab countries as the governing body of the Palestinian people. However, the Palestinians remained without a homeland and continued to fight for one, often resorting to terrorist tactics. In 1993 Israel and the PLO, still under Arafat's leadership, officially recognized each other. In an internationally brokered agreement, Israel agreed that by early 1996 it would withdraw its troops from the Gaza Strip, a tiny ribbon of land along the Mediterranean and bordering Egypt, and most cities and towns of the West Bank, a larger region lying west of the Jordan River and Dead Sea. The city of Jerusalem, recognized by both Israelis and Palestinians as their capitals, straddles the western border of the West Bank and is divided into an Arab East Jerusalem and a Jewish Israeli West Jerusalem. The 1993 Arab-Israeli Agreement, called the Oslo Accords, effectively carved out an autonomous Palestinian homeland, or at least an autonomous region. To govern this region, the Palestinian Authority, PA, was set up. In 1994 Arafat and Israeli leaders Yitzhak Rabin, 1922 to 1995, and Shimon Peres, 1923, were awarded the Nobel Peace Prize for their efforts. In January 1996 Palestinians in the Gaza Strip and the Palestinian-controlled parts of the West Bank elected a legislature and a president, Arafat, to govern these areas. But the accords foundered, both sides contributed to an escalation of violence in the long-troubled region. In 2003 the Roadmap for Peace, developed by the United States, in cooperation with Russia, the European Union, and the United Nations, was presented to Israel and the Palestinian Authority, PA. The plan outlined clear goals and timelines for their achievement for both sides. Still the violence continued, with both sides failing to take the reciprocal steps necessary to peaceably coexist in the region. Cautious hopes for peace were again raised in February 2005 when Palestinian leader Mahmoud Abbas, who in January succeeded Arafat, and Israeli Prime Minister Ariel Sharon met at an Egyptian resort for summit talks. The two announced a verbal ceasefire pledge. Sharon promised that the Israeli military would end assaults on Palestinians, and Abbas vowed to bring an end to militant attacks on Israelis. But there were obstacles to the agreement. Israeli settlements in the Gaza Strip and West Bank needed to be dismantled. The Palestinians needed to gain control of the militant group Hamas, responsible for hundreds of acts of terrorism against Israelis, and the Israeli military needed to step down its responses. The Palestinian government remained tied to the PLO.
What is habeas corpus?
The writ of habeas corpus, which is roughly translated from the Latin as "you should have the body," is considered a cornerstone of due process of law. It means that a person cannot be detained unless he or she is brought in person before the court, so the court can determine whether or not the person is being lawfully held. The notion dates back to medieval England. Many historians believe that habeas corpus was implied by the Magna Carta. 1215, Article 39 states, "No freeman shall be taken or imprisoned, or exiled, or in any way destroyed, except by the lawful judgment of his peers or by the law of the land." The writ was reinforced by Britain's Habeas Corpus Amendment Act of 1679, which stated that the Crown, King or Queen, cannot detain a prisoner against the wishes of Parliament and the courts. The English introduced the concept in the American colonies. And when the U.S. Constitution 1788 was written, it declared, in Article I, Section 9, that habeas corpus shall not be suspended unless when in cases of rebellion or invasion the public safety may require it. For example, during the Civil War, 1861–65, President Abraham Lincoln 1809–1865, suspended habeas corpus, and during Reconstruction, 1865–77. It was again suspended in an effort to combat the activities of the Ku Klux Klan.
Was Indira Gandhi related to Mohandas Gandhi?
No, the two were not related, except by events. After India achieved independence in 1947, the country's first Prime Minister was Jawaharlal Nehru. 1889–1964, who had been a follower of Mohandas Gandhi, 1869–1948. The great leader of India's long struggle for autonomy from Great Britain. During his entire tenure, 1947–64, as leader of India, Nehru was assisted by his only child, Indira, 1917–1984, who in 1942 married a man named Feroz Gandhi of no relation to Mohandas Gandhi. Indira Gandhi took an active role in India's national affairs. After her father died, she went on to become Prime Minister in 1966. However, hers was a troubled tenure. Found guilty of employing illegal election practices, Indira Gandhi was ousted by her political opponents in 1977. Determined to return to power, she was re-elected to Parliament in 1980 and again served as Prime Minister until her death in 1984. She was assassinated by two of her own security guards, Sikhs who were motivated by religious reasons. Her son and successor, Rajiv Gandhi, 1944–1991, was also assassinated, in 1991.
Who are considered the founding fathers of the United States?
The term is used to refer to a number of American statesmen who were influential during the revolutionary period of the late 1700s. Though definitions vary, most include the authors of the Declaration of Independence and the signers of the U.S. Constitution among the nation's founding fathers. Of the 56 members of the Continental Congress who signed the Declaration of Independence, July 4, 1776. The most well-known are John Adams, 1735–1826, and Samuel Adams, 1722–1803, of Massachusetts, Benjamin Franklin, 1706–1790, of Pennsylvania, John Hancock, 1737–1793, of Massachusetts, and Thomas Jefferson, 1743–1826, of Virginia. The 39 men who signed the U.S. Constitution on September 17, 1787, include notable figures such as George Washington, 1732–1799, who would go on, of course, to become the first President of the United States. Alexander Hamilton, 1755–1804, who, as a former military aide to George Washington, went on to become the first U.S. Secretary of the Treasury, and James Madison, 1751–1836. Who is called the father of the Constitution for his role as negotiator and recorder of debates between the delegates. At 81 years of age, Benjamin Franklin was the oldest signer of the Constitution and was among the 6 statesmen who could claim the distinction of signing both it and the Declaration of Independence. The others were George Clymer, 1739–1813, Robert Morris, 1734–1806, George Read, 1733–1798, Roger Sherman, 1721–1793, and James Wilson, 1742–1798. Patriots and politicians conspicuous by their absence from the Constitutional Convention of 1787 were John Adams and Thomas Jefferson, who were performing other government duties at the time and would each go on to become U.S. President. Samuel Adams and John Jay, 1745–1829. Who were not appointed as state delegates but who continued in public life, holding various federal and state government offices, including governor of their states, and Patrick Henry, 1736–1799, of Virginia, who saw no need to go beyond the Articles of Confederation, 1777, to grant more power to the central government. Henry's view on this issue foreshadows the discontent that crested nearly 100 years later when 12 Southern states, including Virginia, seceded from the Union, causing the Civil War, 1861–65, to break out. Adams, Franklin, Hancock, Jefferson, Washington, Hamilton, Madison, Jay, and Henry. These are the names that come to mind when the words Founding Fathers are uttered. Each of them had a profound impact in the political life of the United States even beyond their starring roles as patriots and leaders during the American Revolutionary era. However, it's important to note that in many texts and to many Americans, the term Founding Fathers refers only to the men who drafted the U.S. Constitution, since it is that document that continues more than 200 years after its signing to provide the solid foundation for American democratic government.
Supreme Court decided?
Article 3 of the U.S. Constitution, 1788, states that the judicial power of the United States shall be vested in one Supreme Court. It goes on to describe the High Court's jurisdiction, but it does not specify how the court was to be formed or how many justices it would consist of. These matters were left to Congress, which in 1788, the year the Constitution was ratified, passed the first Judiciary Act, formulating the court's original organization. It had just 6 members, the Chief Justice, plus 5 associates. Subsequent congressional acts have modified the Supreme Court's organization and jurisdiction. Since 1869 the court has consisted of 9 members. The Chief Justice and 8 associates who, once named, serve for life. Justices are appointed by the President but must be approved by the Senate. According to Article 2 of the Constitution, to avoid partisanship, Congress is prevented from lowering the salaries of any of the justices, and justices can only be removed from the bench by impeachment. A formal document that charges a public official with misconduct. Cases reach the High Court through appeal, lower court decisions that are formally challenged, and the justices make their rulings based on a majority vote. Who was the first Chief Justice of the U.S.?
What were Napoleon's 100 days?
The term refers to Napoleon Bonaparte's last 100 days as ruler of France. Having been defeated by his enemies, a coalition of European powers, Britain, Sweden, Austria, and Prussia, who aligned themselves against Napoleon's domination, the emperor abdicated the throne in the spring of 1814. And was exiled to the island of Elba in the Mediterranean Sea. There he heard of the confusion and discontent that came after he had descended the throne. He left Elba, and with more than 1,000 men, arrived on the French coast at Caen and marched inland to Paris. Hearing of his arrival, the new Bourbon king, Louis XVIII, 1755 to 1824, fled. On March 20 Napoleon began a new reign, but it was only to last until the European allies defeated him again. At the Battle of Waterloo, June 12 through 18. After that battle, the so-called Little Corporal, for his diminutive stature, was permanently exiled to the British island of St. Helena, where he remained until his death in 1821.
What are the Geneva Conventions?
The Geneva Conventions are humanitarian treaties signed by almost all of the approximately 200 nations in the world today. There were 189 signatories as of 2003. The treaties were forged in Geneva, Switzerland, in 1864, 1906, 1929, and 1949. The initial protocols, of 1864, gave rise to the Red Cross. There were two amendments, called Protocols, in 1977. In their entirety, the Geneva Conventions set standards for how signatory nations are to treat the enemy during war. They cover access to and treatment of battlefield casualties, treatment of prisoners of war, POWs, and the treatment of civilians. The summaries of each convention and protocol are as follows. Convention I. For the amelioration of the condition of the wounded and sick in armed forces in the field. Sets forth the protections for members of the armed forces who become wounded or sick. Convention II, for the amelioration of the condition of wounded, sick, and shipwrecked members of armed forces at sea. Extends protections to wounded, sick, and shipwrecked members of the naval forces. Convention III, relative to the treatment of prisoners of war, Geneva. Lists the rights of prisoners of war. Convention IV, relative to the protection of civilian persons in time of war, Geneva. Deals with the protection of the civilian population in times of war. All four conventions were ratified as a whole in 1949. Protocol I. Additional to the Geneva Conventions of August 12, 1949, and relating to the protection of victims of international armed conflicts. Extends protections to victims of wars against racist regimes and wars of self-determination. Protocol II, additional to the Geneva Conventions of August 12, 1949. And relating to the protection of victims of non-international armed conflicts. Extends protections to victims of internal conflicts in which an armed opposition controls enough territory to enable them to carry out sustained military operations. The Geneva Conventions, along with the Hague Conventions, 1899, 1907, comprise much of what is called international humanitarian law, IHL. Because so many nations of the world have ratified both the Geneva Conventions and the Hague Conventions, they are considered customary international law, which means they are binding on all nations.
How many nations are members of the UN today?
In 2005, the United Nations, UN, membership stood at 191 nations, with the most recent additions having been Switzerland and Timor-Leste, East Timor, in 2002. The membership of the UN grew steadily after it was founded in 1945. Originally there were 51 member states, including Canada, France, the United Kingdom, the USSR, today the Russian Federation, and the United States. Within a decade, 25 more countries had been added to the UN's membership roster. By 1965 there were 117 members, by 1975 144 members, by 1985 159 members, and by 1995 185 members.
What are the bodies and agencies of the United Nations?
The UN's charter establishes 6 main bodies and explains their duties and operating methods. The General Assembly is the major forum, all member nations are represented there. And the Assembly can discuss any issue that is deemed relevant and important to the UN. The Security Council has the major responsibility for preserving peace. The Economic and Social Council investigates economic questions and works to improve living standards. The Secretariat is the UN's administrative body. Helping all organs do their work, the Trusteeship Council assists non-self-governing territories. And the International Court of Justice hears disputes between member nations. Except for the last one, all bodies convene in the UN headquarters in New York City. The International Court of Justice meets in The Hague. Since the Charter was written in 1945, the United Nations has established numerous agencies, committees, and commissions to help carry out its work around the world. Among those that are most well known to the public are the United Nations Educational, Scientific, and Cultural Organization, UNESCO, which encourages the exchange of ideas among nations. The United Nations International Children's Emergency Fund, UNICEF, which assists children and adolescents worldwide, particularly those in devastated areas or developing countries. The World Health Organization, WHO, which promotes high health standards around the globe. The International Labour Organization, ILO, which works to improve labor conditions and protect workers. And the International Monetary Fund, IMF, which addresses currency and trade issues.
What was Operation Falcon?
It was the code name for the mid-April 2005 roundup of more than 10,000 fugitives in 1 week. The coordinated nationwide effort was led by the U.S. Marshals Service, together with officers from 960 federal, state, and local law enforcement agencies. The Marshals arrested 10,340 people who were wanted for various crimes, many of them violent. The operation took place during Crime Victims' Rights Week. More than 150 of the fugitives were wanted for murder, 550 for sexual assault charges, and more than 600 for armed robberies. There were also escaped prisoners and criminal suspects among those arrested. Operation Falcon was a landmark in law enforcement because of the sheer number of arrests. Previous coordinated efforts had nabbed only hundreds of fugitives.
What is the G8?
It is the Group of Eight, an annual meeting of the world's leading industrial democracies. Canada, France, Germany, Italy, Japan, Russia, the United Kingdom, and the United States. It began as the Group of Six, with the 1975 conference in France. where representatives of 6 nations, France, Germany, Italy, Japan, the United Kingdom, and the United States, met to discuss international economic and political issues. The goal of the meeting was to shore up cooperation on matters of concern to the member nations. Canada joined the group in 1976 and Russia in 1994, though the nation did not participate fully in the sessions until 1998. Hosting responsibilities rotate among the 8 member countries. In 2004, the United States hosted the 30th meeting, on an island off the coast of Georgia. Among the agenda items were the training of international peacekeepers, setting up a global initiative to develop a human immunodeficiency virus, HIV, vaccine, and developing a plan to end famine in the Horn of Africa. Easternmost Africa, including Somalia, Ethiopia, and Djibouti. By 2009, the leaders and representatives of non-G8 countries were invited to participate in discussions relevant to them.
Who started the Boston Tea Party?
Many believe that on December 13, 1773, it was Patriot Samuel Adams, 1722–1803, who gave the signal to the men, who may have numbered more than 100 and were dressed as Indians, to board the ships in Boston Harbor and dump the tea overboard. Whether or not it was Adams who started the Tea Party, about this there can be no doubt. He was most certainly a leader in the agitation that led up to the event. The show of resistance was in response to the recent passage by the British Parliament of the Tea Act, which allowed the British-owned East India Company to dump tea on the American colonies at a low price, and also required that the colonists pay a duty for said tea. Colonists feared the act would put local merchants out of business, and that if they conceded to pay the duty to the British, they would soon be required to pay other taxes as well. Once the ships carrying the tea had arrived in Boston Harbor, the colonists tried to have them sent back to England. But when Governor Thomas Hutchinson, 1711–1780, of Massachusetts refused to order the return of the ships, Patriots organized their show of resistance, which came to be known as the Boston Tea Party.
Why is Napoleon still controversial?
Even history has not been able to sort out the widely disparate opinions of the diminutive French ruler. And both the detractors and the champions, or some would say the apologists, continue to publish their arguments and supporting research. The most obvious point on which scholars differ centers on the fact that, first and foremost, Napoleon Bonaparte, 1769–1821, was a military man. Here opinion divides quite naturally. Not long after Napoleon assumed power, in the coup of 1799, he proceeded to keep France and the rest of Europe at war for more than 10 years. From the French perspective, Napoleon was a great man. a brilliant strategist who could not only muster his troops but could keep them motivated to fight one campaign after another. The targets of these campaigns: England, Russia, Austria, Germany, Spain, and Portugal among them view Napoleon in quite a different light, as would be expected. Researchers from these countries have seen and rendered Napoleon's dark side, calling him a megalomaniac and a psychopath, and even seeing him as a forerunner of Adolf Hitler, 1889 to 1945. To further complicate the matter of how history views Napoleon, before he declared himself emperor for life in 1804, and launched his military conquests throughout the continent and beyond, 1805. Napoleon enjoyed a brief period in which many Europeans, not just the French, believed him to be a hero. After all, he assumed leadership of France after the hideous period of Robespierre's terror and the ineffectual government of the Directory. And then he proceeded to make peace with the Americans, the Russians, and the British. Many believed Napoleon was just the man to bring order to the chaos France had known since the storming of the Bastille. And he extended an olive branch to France's longtime enemies. It looked like he would restore order at home and abroad. Of course, this honeymoon did not last. By 1805, the leader many had looked to end the turmoil only became the cause of more turmoil. His compulsive war-making, as one writer put it, soon swept over the continent, ultimately uniting various countries in an effort to rid Europe of the scourge that was Napoleon and his Grand Army. Thus, students and readers are left to sort through the diverging accounts of this controversial figure. Napoleon has been called the Emperor of Kings, credited for his vision, insight, courage. And even with the development of the modern liberal democracy, he has also been described as a compulsive tyrant who had an insatiable appetite for battle, a man whose own ambitions left millions dead. But on a few descriptions both sides can agree: he was a brave soldier, an inspired military leader, and, at least for a time, a charismatic ruler.
Why was Mohandas Gandhi called Mahatma?
Mohandas Gandhi was called Mahatma, meaning great-souled, by the common people, who viewed him as India's national and spiritual leader. He is considered the father of his country. He was born in India on October 2, 1869. As a young man, Gandhi studied law in Britain. Practicing briefly in India, he then travelled to British-controlled South Africa on business. Observing oppressive treatment of Indian immigrants there, he held his first campaign of passive resistance. Gandhi would later become very well known for this method of protest, called satyagraha, meaning firmness in truth. Back in India as of 1915, Gandhi organized a movement of the people against the British government there. Britain had taken control of India during the 1700s and remained in power. After World War I, 1914-18, Indian nationalists fought what would be a long and sometimes bitter struggle for political independence. While Gandhi's protests took the form of nonviolent campaigns of civil disobedience, such as boycotts and fasts, hunger strikes, he was more than once arrested by the authorities for causing disorder. As his actions inspired more extreme measures on the part of his followers, whose protests took the form of rioting. As a member and, later, the president of India's chief political party, the Indian National Congress, Gandhi led a fight to rid the country of its rigid caste system, which organizes Indian society into distinct classes and groups. In Gandhi's time, not only were there four varna, or social classes, but there was a fifth group of untouchables who ranked even below the lowest class of peasants and laborers. Improving the lot of the untouchables was of tantamount importance to the leader, who by this time had abandoned Western ways in favor of a life of simplicity. Beginning in 1937, Gandhi became less active in government, giving up his official roles. But he continued to be regarded as a leader of the independence movement. During World War II, 1939–45, he was arrested for demanding British withdrawal from the conflict. Released from prison in 1944. Gandhi was central to the post-war negotiations that in 1947 resulted in an independent India. A believer in the unity of humankind under one God, he remained tolerant to Christian and Muslim beliefs. Amidst an outbreak of violence between Hindus and Muslims, Gandhi was on a prayer vigil in New Delhi when a Hindu fanatic fatally shot him in 1948.
What is international law?
As interpreted by Dutch jurist and humanist Hugo Grotius, 1583–1645. Natural law prescribes the rules of conduct among nations, resulting in international laws. His 1625 work, titled Concerning the Law of War and Peace, is considered the definitive text on international law, asserting the sovereignty and legal equality of all states of the world. But the notion also had its detractors, English philosopher Thomas Hobbes, 1588–1679, among them. Hobbes insisted that since international law is not enforced by any legal body above the nations themselves, it is not legitimate. Since the 17th century, however, international law has evolved to become more than just theory. During the 1800s and early 1900s, the Geneva Conventions 1864, 1906, 1929, 1949, and the Hague Conferences, 1899, 1907, set forth the rules of war. Today, treaties, between two or among many countries, customary laws, legal writings, and conventions all influence international law, which is also referred to as the law of nations. Further, it is enforced by the International Court of Justice, a United Nations body, as well as by world opinion, international sanctions, and the intervention of the United Nations, apart from the International Court of Justice.
What does the UN do?
Representatives of member countries work to keep peace and ensure security for people around the globe. Over the decades, the UN has expanded its role as a provider of humanitarian aid and stepped up its efforts in the area of human rights. When disputes arise, the UN works toward diplomatic resolution. Though not always successful in its role as peacekeeper or peace negotiator, the organization has provided a forum for debate, which has prevented some disputes from developing into major wars. And through its various agencies, the UN provides assistance to developing nations, promotes humanitarian causes, and sends relief to war-torn areas. However, critics have charged the international organization with arbitrarily defining borders between countries, saying that these drawn boundaries divide ethnic groups and result in conflicts, such as in the Middle East and Africa.
Why were there two continental congresses?
Both meetings were called in reaction to British Parliament's attempts to assert its control in the American colonies. When colonial delegates to the First Continental Congress met, they developed a plan but were obviously prepared for it not to work, since even before dismissal they agreed to reconvene if it were necessary to do so. In short, the First Congress developed Plan A, the Second resorted to Plan B, which was one last appeal to the King, and then to Plan C, finally declaring independence from Britain. The First Continental Congress convened on September 5, 1774, in Philadelphia, Pennsylvania. The meeting was largely a reaction to the so-called Intolerable Acts, or the Coercive Acts, which British Parliament had passed in an effort to control Massachusetts after the rebellion of the Boston Tea Party, December 1773. Sentiment grew among the colonists that they would need to band together in order to challenge British authority. Soon 12 colonies dispatched 56 delegates to a meeting in Philadelphia. The 13th colony, Georgia, declined to send representatives but agreed to go along with whatever plan was developed. Delegates included Samuel Adams, 1722–1803, George Washington, 1732–1799. Patrick Henry, 1736–1799, John Adams, 1735–1826, and John Jay, 1745–1829. Each colony had one vote, and when the meeting ended on October 26, the outcome was this. The Congress petitioned the King, declaring that the British Parliament had no authority over the American colonies, that each colony could regulate its own affairs, and that the colonies would not trade with Britain until Parliament rescinded its trade and taxation policies. The petition stopped short of proclaiming independence from Great Britain, but the delegates agreed to meet again the following May if necessary. But King George III, 1738 to 1820, was determined that the British Empire be preserved at all costs. He believed that if the empire lost the American colonies, then there may be a domino effect, with other British possessions encouraged to also demand independence. He feared these losses would render Great Britain a minor state, rather than the power it was. Britain unwilling to lose control in America. In April 1775, fighting broke out between the Redcoats and Patriots at Lexington and Concord, Massachusetts. So, as agreed, the colonies again sent representatives to Philadelphia. Convening the Second Continental Congress on May 10. Delegates including George Washington, John Hancock, 1737 to 1793. Thomas Jefferson, 1743 to 1826, and Benjamin Franklin, 1706 to 1790, organized and prepared for the fight. Creating the Continental Army and naming Washington as its commander-in-chief. With armed conflict already underway, the Congress nevertheless moved slowly toward proclaiming independence from Britain. On July 10, 2 days after issuing a declaration to take up arms, Congress made another appeal to King George III, hoping to settle the matter without further conflict. The attempt failed, and the following summer the Second Continental Congress approved the Declaration of Independence. Breaking off all ties with the mother country.
What were the Jim Crow laws?
They were laws or practices that segregated blacks from whites. They prevailed in the American South during the late 1800s and into the first half of the 1900s. Jim Crow was a stereotype of a black man described in a 19th-century song and dance act. The first written appearance of the term is dated 1838. And by the 1880s it had fallen into common usage in the United States. Even though in 1868 Congress passed the 14th Amendment, prohibiting states from violating equal protection of all citizens. Southern states passed many laws segregating blacks from whites in public places. In short, the laws were both manifestation and enforcement of discrimination. Thanks to the civil rights movement, the laws were finally found to be unconstitutional during the 1950s and 1960s.
What was the Supreme Court's role in racial segregation?
Though most segregation laws, or Jim Crow laws, were overturned by decisions of the Supreme Court during the 1950s and 1960s, the court was righting its own wrong, in the late 1800s. During the years following the Civil War, 1861 to 65, and the abolition of slavery, the Supreme Court made rulings that actually supported segregation laws at the state level. The most famous of these was the 1896 case of Plessy v. Ferguson, in which the highest court in the land upheld the constitutionality of Louisiana's law requiring separate but equal facilities for whites and blacks in railroad cars. One strong dissenting opinion came from Associate Justice John Marshall Harlan, who declared the Constitution is color blind. Following the Plessy v. Ferguson decision, states went on to use the separate but equal principle for 50 years, passing Jim Crow laws that set up racial segregation in public schools, transportation, and in recreation, sleeping, and eating facilities. This meant there were drinking fountains, benches, restrooms, bus seats, hospital beds, and theater sections designated as whites only or colored. One Arkansas law even provided that witnesses being sworn in to testify in a courtroom be given different Bibles depending on the color of their skin. Two landmark Supreme Court decisions came in 1954 and 1960 in the cases of Brown v. the Board of Education and Boynton v. Virginia. In the first case, parents of black children in Topeka, Kansas, elementary schools charged that the segregation of white and black students in the public schools denied black children the equal protection cited in the 14th Amendment, 1868. The parents were supported in their fight by the NAACP, National Association for the Advancement of Colored People, whose legal counsel included Thurgood Marshall, 1908 to 1993. On May 17, 1954, the Supreme Court ruled that segregated schools do violate the Equal Protection Clause, overturning the separate but equal doctrine previously upheld by Plessy v. Ferguson. The federal government again made a stand against state segregation laws when, in December 1960, Chief Appellant Lawyer Thurgood Marshall argued the case of Howard University law student Bruce Boynton before the Supreme Court, again ruling in favor of the plaintiff, who had charged that the segregation laws at the Richmond, Virginia, bus station violated the federal anti-segregation laws. Washington sent a clear message to the states that public facilities are for the use of all citizens, regardless of color. These decisions combined with the activism of the civil rights movement to outlaw racial segregation.
Why was the Dred Scott decision important?
The decision in the case of Dred Scott pronounced the Missouri Compromise 1820 unconstitutional and served to deepen the divide between North and South, helping pave the way for the Civil War, 1861–65. In the mid-1800s Dred Scott, c. 1795–1858, who had been born into slavery in Virginia, tried to claim his freedom on the basis that he had traveled with his owner, a doctor, in Wisconsin and Illinois, where slavery had been prohibited by the Missouri Compromise. By the Compromise, Congress decided to admit Missouri as a slavery state and Maine as a free state, and declared that the territories north of the 36th parallel, present-day Missouri's southern border, were free, with the exception of the state of Missouri. After a lifetime of slavery, Dred Scott sued Missouri for his freedom in April 1846. The case, which hinged on Scott's travels in free territories in the North, Went through 2 trials, the second was granted due to a procedural error in the first. In 1850, at the conclusion of the second trial, a Missouri jury ruled Scott a free man based on precedents that indicated residence in a free territory or state resulted in emancipation, regardless of the fact that Missouri itself was a slave state. John F. A. Sanford, the lawyer for Scott's owner, immediately appealed the decision before the Missouri Supreme Court, where a pro-slavery judge reversed the ruling, rescinding Scott's freedom. But the case was not over yet, because Sanford had filed the court papers under his own name rather than that of Scott's former owner, the case of Scott v. Sanford. Because of a filing error, the case is also rendered as Scott v. Sanford, took an interesting twist. Scott hired a new lawyer who was able to get the case before the federal court. Sanford had moved to New York, and since the appellant, Scott, and the registered defendant, Sanford, were now residents of different states, the case came under federal purview. In 1854 a circuit court in St. Louis again heard Dred Scott's case, but his freedom was again denied. This decision was appealed to the U.S. Supreme Court, which began hearing the case in 1856. In March 1857 the Supreme Court, which had a Southern majority, ruled that Scott's residence in Wisconsin and Illinois did not make him free, that a black, a Negro descended from slaves, had no rights as an American citizen and therefore could not bring suit in a federal court, and that Congress never had the authority to ban slavery in the territories. Dred Scott died the following year.
Why was the Dred Scott decision important?
The decision in the case of Dred Scott pronounced the Missouri Compromise 1820 unconstitutional and served to deepen the divide between North and South, helping pave the way for the Civil War, 1861–65. In the mid-1800s Dred Scott, c. 1795–1858, who had been born into slavery in Virginia, tried to claim his freedom on the basis that he had traveled with his owner, a doctor, in Wisconsin and Illinois, where slavery had been prohibited by the Missouri Compromise. By the Compromise, Congress decided to admit Missouri as a slavery state and Maine as a free state, and declared that the territories north of the 36th parallel, present-day Missouri's southern border, were free, with the exception of the state of Missouri. After a lifetime of slavery, Dred Scott sued Missouri for his freedom in April 1846. The case, which hinged on Scott's travels in free territories in the North, went through 2 trials, the second was granted due to a procedural error in the first. In 1850, at the conclusion of the second trial, a Missouri jury ruled Scott a free man based on precedents that indicated residence in a free territory or state resulted in emancipation, regardless of the fact that Missouri itself was a slave state. John F. A. Sanford, the lawyer for Scott's owner, immediately appealed the decision before the Missouri Supreme Court, where a pro-slavery judge reversed the ruling, rescinding Scott's freedom. But the case was not over yet, because Sanford had filed the court papers under his own name rather than that of Scott's former owner, the case of Scott v. Sanford. Because of a filing error, the case is also rendered as Scott v. Sanford, took an interesting twist. Scott hired a new lawyer who was able to get the case before the federal court. Sanford had moved to New York, and since the appellant, Scott, and the registered defendant, Sanford, were now residents of different states, the case came under federal purview. In 1854 a circuit court in St. Louis again heard Dred Scott's case, but his freedom was again denied. This decision was appealed to the U.S. Supreme Court, which began hearing the case in 1856. In March 1857 the Supreme Court, which had a Southern majority, ruled that Scott's residence in Wisconsin and Illinois did not make him free, that a black, a Negro descended from slaves, had no rights as an American citizen and therefore could not bring suit in a federal court, and that Congress never had the authority to ban slavery in the territories. Dred Scott died the following year.
What was drive? Mudd tried for?
A doctor who treated the broken ankle of John Wilkes Booth, 1838 to 1865, after Booth shot President Abraham Lincoln. On April 14, 1865, he died the next day. Samuel Mudd was later charged as an accomplice in the president's assassination and was charged with treason and conspiracy. He was tried before a military commission and on June 30, 1865, was found guilty and sentenced to life in prison. 3 years later Mudd was pardoned by President Andrew Johnson, 1808 to 1875. The official reason for the pardon was Mudd's humanitarian efforts to save lives during a prison epidemic. But the case against him had been flimsy at best, and history has credited the guilty verdict to overly ambitious politics and a commission bent on retribution. Nevertheless, Mudd's name remained tainted, giving the popular culture the phrase, "His name is Mudd."
What was drive? Mudd tried for?
A doctor who treated the broken ankle of John Wilkes Booth, 1838 to 1865, after Booth shot President Abraham Lincoln. On April 14, 1865, he died the next day. Samuel Mudd was later charged as an accomplice in the president's assassination and was charged with treason and conspiracy. He was tried before a military commission and on June 30, 1865, was found guilty and sentenced to life in prison. 3 years later Mudd was pardoned by President Andrew Johnson, 1808 to 1875. The official reason for the pardon was Mudd's humanitarian efforts to save lives during a prison epidemic. but the case against him had been flimsy at best. And history has credited the guilty verdict to overly ambitious politics and a commission bent on retribution. Nevertheless, Mudd's name remained tainted, giving the popular culture the phrase, "His name is Mudd."
Why was Susan B. Anthony tried?
Susan B. Anthony, 1820 to 1896, was tried for violating federal voting laws. The suffrage movement was in full swing in 1872 when Anthony and 14 female companions went to the Rochester, New York, voter registration office and demanded to be registered. When the officials refused, Anthony argued with them, showing them the written opinion of a Judge Henry R. Selden, who agreed with her, and others, that the 14th Amendment 1868 also protects women's rights, including the right to vote. She threatened the registrars that she would sue them if they did not allow her to participate in elections. They gave in and the women signed up to vote. On election day, November 5, they did just that. 23 days later, all 15 women were arrested for having done so. Bail was set, and eventually all the women were released. The following June, Anthony's trial got underway. The U.S. District Attorney presented the government's case against her. She had upon the 5th day of November 1872, voted. At which time she was a woman. She was found guilty and ordered to pay a fine of $100. In another act of civil disobedience, Anthony refused to pay it, saying, "Resistance to tyranny is obedience to God." In the coming years, the nation's courts continued to narrowly interpret the 14th Amendment to the U.S. Constitution, to the exclusion of women. Anthony died 24 years before American women were granted suffrage. After the 19th Amendment was made in 1920.
Why was Susan B. Anthony tried?
Susan B. Anthony, 1820 to 1896, was tried for violating federal voting laws. The suffrage movement was in full swing in 1872 when Anthony and 14 female companions went to the Rochester, New York, voter registration office and demanded to be registered. When the officials refused, Anthony argued with them, showing them the written opinion of a Judge Henry R. Selden, who agreed with her, and others, that the 14th Amendment 1868 also protects women's rights, including the right to vote. She threatened the registrars that she would sue them if they did not allow her to participate in elections. They gave in and the women signed up to vote. On election day, November 5, they did just that. 23 days later, all 15 women were arrested for having done so. Bail was set, and eventually all the women were released. The following June, Anthony's trial got underway. The U.S. District Attorney presented the government's case against her. She had upon the 5th day of November 1872, voted. At which time she was a woman. She was found guilty and ordered to pay a fine of $100. In another act of civil disobedience, Anthony refused to pay it, saying, "Resistance to tyranny is obedience to God." In the coming years, the nation's courts continued to narrowly interpret the 14th Amendment to the U.S. Constitution, to the exclusion of women. Anthony died 24 years before American women were granted suffrage. After the 19th Amendment was made in 1920.